Hello, everybody. Good morning. I'm Nancy Lindholm, CEO of the Oxnard Chamber of Commerce. Thanks for joining us today for a webinar on the current California law regarding independent contractors versus employees. This is the first in a series of presentations that the Oxnard Chamber of Commerce will be providing to keep its members informed about, of course, labor laws, business financing, government issues, local politics, and much more. We are thrilled and honored to have Brian Koegle with us today to cover the topic of independent contractors and employees. Brian Koegle is a partner in the Employment and Labor Law Department of Poole, Shaffery, and Koegle, LLP. With a focus on labor and employment law, Mr. Koegle provides counsel to employers across various industries regarding hiring practices, employment contracts, wage and hour issues, compensation, discipline, and termination matters. He represents employers in mediation, arbitration, litigation, and various administrative hearings, defending a wide range of employment discrimination and fair employment practice cases. He also assists employers in the design, drafting, modification, and implementation of personnel policies, procedures, employee handbooks, and conducts personnel policy audits as well. Mr. Koegle guides employers with respect to all aspects of wage and hour compliance, including overtime calculations, meal and rest period requirements, and statutory penalties arising from non-compliant policies and procedures. He also counsels employers on leaves of absence, including family and medical leaves, alcohol and drug rehabilitation leaves, and leaves involving pregnancy-related disabilities. He is a frequent writer and speaker on a variety of labor and employment-related matters. In addition, Mr. Koegle counsels business owners with regard to business and commercial disputes, including protection of trade secrets and proprietary information, and has first chair trial experience litigating business and employment matters. Mr. Koegle is a member of the labor and employment sections of the California State Bar and the Los Angeles County Bar Association, and serves as an associate fellow in the Litigation Council of America. He has been recognized by Super Lawyers, Los Angeles Magazine, each year between 2010 and 2020, 2010 through 2015 as a rising star, and 2016 through 2020 as Super Lawyer. Brian has a Bachelor of Arts in Psychology from Ohio State University, go Buckeyes, and also his Juris Doctorate from Southwestern University School of Law. While Brian is pulling up his screen, I wanted to explain the format for today's webinar. We will receive Brian's presentation first and then go into Q&A. You can post inquiries in the questions feature, which you can find on the right side of your screen. Okay, Brian, I am turning it over to you.
Excellent. Well, thank you, Nancy. I very much appreciate that kind introduction. And I'm thrilled to see everybody, well, not see everybody, but everybody gets to see me today doing a new presentation. I will tell you that of the 45 presentations that I've done in the last 100+ days, I'm really glad to be talking about something other than COVID-19. It's quite exciting, actually, for me to be able to work through and talk with something different. What's fascinating is the fact that while this was the hot topic from January through March, it kind of took a back seat because of all the COVID-19 stuff. Nancy, I just want to confirm that everyone is able to see my screen with the PowerPoint presentation.
Yes, we can see your presentation. If you could put it in slideshow mode, will be really good.
There we go.
Perfect. Thank you.
Right. Excellent. Thank you. All right. So we've got a lot to get caught up on because this, again, it was a very, very hot topic in 2019 and the first quarter of 2020. A lot was put on the back burner as a result of COVID-19. But this is still very much a hot topic, even with some late breaking news as of late Tuesday night that we'll talk about here on the slide deck. So first and foremost, I want to make sure that everybody understands where we're coming from a big picture standpoint. Understanding that if you're doing business in the great state of California, there is a presumption, a legal presumption that indicates that anytime you have someone performing labor for you or for your business, that that individual is assumed to be an employee. Unless you can specifically fit an employee in a very, very narrow box of explanation as an independent contractor, they will revert back, they will default to employment status. We're going to end the presentation talking about why that's important, making sure that everybody is understanding on what the new obligations are from an employment standpoint. But I do want to start our presentation today leaping off talking about independent contractors. And as I always do, I always have to start these presentations with a story. What has been ironic over the course of the last 2.5 years, and I'll explain to you why it's been 2.5 years, we have, as attorneys, been dealing with a huge flood of new claims that are coming from all different angles. Department of Labor, the local labor commissioner in California, the EDD, Employment Development Department, lawsuits and claims of misclassification. But this actually involves a workers' compensation situation. About 1.5 years ago, client comes to us and they're being audited by their workers' compensation carrier. This is a specialized organization that does interpreting and translating services. They have over 250 translators in the state of California, many of which are very specialized. All of these translators have their own business enterprise. In other words, they work for multiple translating companies. Have job, will travel. They go to multiple locations throughout the state. Most of them have a specialized dialect or a specialized language that they focus within. They also make sure that they are working in different venues, court systems, depositions, private interpreting events. Truly at the core of what an independent contractor truly is. Well, this workers' compensation carrier disagreed. And because this was a relatively small business with only 2 or 3 employees, their annual premiums for workers' compensation insurance was $12,500. Well, when the insurance company came in, they performed an audit. They made a determination on their own that those folks should have been deemed employees and not independent contractors, and they submitted an invoice for past due workers' compensation premiums for a period of 3 years, totaling $618,400. Pretty substantial. And for a small business like my client, they weren't in a position where they were able to fight this situation back because the insurance company basically has the final say on how they handle it. So just because you feel like you may be in a safe condition or a safe position today with your independent contractors, do not underestimate the fact that you could have the rug pulled out from underneath you later on. All right. So with that as our scare tactic to start us off, I want to start out where we were back in wonderful March of 2018. The reason we have to go back that far is because that happened a month before the Supreme Court's decision in Dynamics Industries. So before 2018, we were always working under the operations that an independent contractor could be an independent contractor as long as they satisfied an 11-point test. That 11-point test was laid out in 1998 Supreme Court decision called S.G. Borrello and Sons. And as part of that, the Supreme Court laid out what they would look at in order to determine whether a worker was an independent contractor or whether or not they were, in fact, an employee. And much of this goes to, were they engaged in an occupation that was unique? Was their financial investment in their equipment, their tools, their computer systems, their own investment, or the person that they were working for? What kind of skill was required? Do they hold themselves out as an independent business operation working for multiple agencies or enterprises? Is the profit and loss of that worker's sweat equity based upon their effort and not upon some flat fee guaranteed by the business owner? The degree of the permanence of the working relationship. Is this a temporary project by project relationship, or is this something where a person is performing regular work for a single enterprise on a regular basis? How we paid those individuals, whether it was by the job, by the project, or by the hour. And then whether or not the parties actually believed that they were entering into an independent contractor basis. All of these elements basically boil down to one analytic point that is most important for everything, and that is, what was the degree of control that the business owner executed over the laborer's work? The higher the degree of control, the less likely that person would be an independent contractor and would most likely default to an employment status. Why? Because if an employer is exercising dominion, control, effort over the working status of the work being done, that is defaulted to be an employment situation. So for years, from the late 1990s up and through 2018, first part of 2018, this was the test that anybody would have to go through when determining whether or not a worker was an independent contractor. And for the most part, we saw a handful of cases each and every year where people would challenge the status quo, suggesting that they shouldn't have been an independent contractor and should have been an employee. Typically, those claims arose when a former independent contractor was no longer in that role. They were terminated, the business relationship ended, etc., and they were frustrated, so they turned around and said, "Ah, wait, you still owe me money because I should have been an employee." But for the most part, they were few and far between, at least in way of court challenges. We shredded the Borello standard, though, with the passage of Dynamics Operations West versus Superior Court. This decision was passed on April 30th, 2018. And this really changed the landscape as we know it today as to who is and is not an independent contractor. As part of that decision, the California Supreme Court laid out what they called a very simple and basic ABC test. As you'll find, it is not as simple and basic as we would like it to be. Basically, the court wanted to streamline the 11-point test that was set forth in the Borello case and say, look, what it's going to boil down to is really these three things. The first element, workers must be free from all control and direction of the hirer in connection with the work. I want to focus on this just real briefly because a lot of folks don't really take into consideration what this means. When they put in the word all, it didn't say most, the way that the prior analytics did. There were very specific examples that were laid out in the Dynamics case that explain when an employer is actually exercising control over the day-to-day activities of a worker. One of those control factors was by setting a deadline. If you say, I need this project done by next Friday, you are exercising some control over the work. In the example that was given by the court in the Dynamics case, they said that that one factor alone, setting a deadline, may be definitive to show that the employer is exercising control, and therefore part A of the test could not be satisfied in those circumstances. The court did go back and say, look, it's a very factual analysis, understanding that when we give assignments or tasks to outside agencies, outside businesses, that we do have an expectation of when the job is going to be complete. But if you're setting hard deadlines or hard delivery dates, then there is a grand possibility that that person will not be deemed to be an independent contractor for your business. The second portion of the test, and by the way, you'll notice that these are all and statements. All three of these positions must be in place in order to qualify as an independent contractor. If even one of the elements is missing, then the reversion back to employment status is automatic. The second part of this test that was laid out by the Supreme Court in Dynamics was whether the worker performs work that is outside the usual course of the hiring entity's business. If you are a widget maker and you bring in somebody in the production, the distribution, the quality control, or the sale of those widgets, that is in the stream of commerce for the product or service that you are selling. As such, those individuals will be deemed to be part of your business and therefore will default back to the employment status. Sales is a great example on this issue. And in fact, the court laid these examples out specifically as it applied to sales. If you have someone who is selling your product and your products alone, meaning they're not selling multiple products within the same industry, and they are selling to your clients, They are basically taking orders. They're issuing invoices or POs. They're ensuring that quality assurance and quality control gets into place, and then they're handling customer service on the back end. If your sales team is doing any of those elements of their job, they are your employees, not independent contractors. This is a huge shakeup in a lot of industries because many, such as beverage distributors, manufacturers of medical devices or implant devices, in history, people had always been treated as independent contractors in those roles. Well, no longer is that the case in California. If they are performing work inside of your business, doing work that is part and parcel for your stream of commerce, they will be deemed to be employees. The third and probably more convoluted portion of the ABC test is whether or not the employee or the worker is customarily engaged in an independently established trade, occupation, or business of the same nature that they're performing. In other words, if you're hiring an attorney to provide you counsel or advice on employment-related issues or on business issues, we are in a very separate and distinct profession, the profession of law. If you bring in somebody who has a very specific specialization that is not necessarily in the course and scope of the work that you provide, that specialized work may be something that is customarily engaged in an independent trade. But the problem is, if you have someone coming in and they are regularly working in your business, and regularly is not defined by the court, by the way, whether that's 10 hours per week, whether that's 10 hours per month, whether that's 10 hours per year, there is no specific delineation of what regular work looks like. But if they're not in a specific independent trade or occupation that is not part of what your business provides, then they're going to default back to the employment status. The last part of this C test is actually kind of ironic, because many times what we do is we say, well, we're bringing in a specialist because we need this widget to have something that we don't normally do. But when that specialist comes in, and if he does something that is in the course and scope of what it is that your business provides, basically giving direction on the manufacturing, if he's overseeing the quality control, if he's selling the product to the end user, that's all deemed part of your stream of commerce. So if he steps out of that independent established occupation or role and does something that other employees within your business are doing, you will run afoul of part C of this test. All right, so these are the three basic elements that went into the dynamics test. Again, the law changed when the Supreme Court passed this provision and put the ruling in dynamics out to the public. But I will tell you that there was a very quiet rollout of the provisions of dynamics. And in fact, many employers elected not to participate, not to change their practice, and to basically fly by the seat of their pants in defiance of the dynamic standard because they weren't worried about the repercussions or the fallout, and they were willing to roll the dice because the cost savings associated with an independent contractor versus an employee were worthwhile to those businesses. So, flash forward to summer of 2019. During that time period, a bill was introduced. It was Assembly Bill 5, introduced by Lorena Gonzalez out of San Diego. Ms. Gonzalez chose to introduce a bill that basically was going to codify the provisions of the dynamics court decision into the California Labor Code. Now, what was interesting was, at the time that dynamics was passed, it was basically interpreting provisions of the California wage orders. And let me just take a moment to explain this. In California, there are multiple sets of rules and regulations that apply to every business owner when it comes to handling employees. The first, kind of the big overarching group, are the California Labor Code provisions. There are over 3,400 provisions of the California Labor Code that every employer, well, not every employer, but most employers in the state of California have to comply with. In addition to the Labor Code provisions, though, there is also something called the Industrial Welfare Commission wage orders. There are 16 different wage orders. Each one applies to a different industry or practice area. Many of you who are in office work or manufacturing work or production or sales work are governed by wage order number 4. Wage order 4 deals with professional, clerical, and manufacturing companies. That has its own rules and regulations that you have to abide by, amongst which are exemption issues. Who is exempt from overtime and meals and rest periods? What the meal and rest periods are for your industry or for your group. So when the dynamics case came out, it was specific as to applying to the California wage orders. It did not go so far as to expand its coverage to the California Labor Code. Assembly Bill 5 did that for us. In other words, under any circumstance, whether we're talking about a violation of California Labor Code Section 226 for pay stubs, whether we're talking about Industrial Welfare Commission Wage Order 4-2001 subsection M, which provides for meal periods within the first 5 hours of a work shift. All of these are now going to be applicable to workers if they are in fact misclassified as independent contractors. So what does this mean for you? Let me take one step back. It was September 19th of 2019 that Governor Newsom signed Assembly Bill 5 into law. The bill became effective on January 1. The fascinating thing about the way that this bill is written, though, is that it is a backward-looking bill. In other words, just because the effective date was January 1, if you were out of compliance on December 31st, 2019, or for any period going back for a period of 3 years, there was liability that was generated on January 1 that creates a problem or exposure for your business. That means that any independent contractor that worked for you over the course of the last 3 years has a claim against you, or could go to one of the California Labor Commissioners or the United States Department of Labor seeking penalties associated with their misclassification. So it's a big change to the law because it has a backward-looking effect, but a forward application as well, meaning January 1 moving forward, additional liabilities will attach. One thing I want to make sure that everybody's careful of, there was an accompanying bill to Assembly Bill 5 that nobody paid much attention to. It was called Assembly Bill 547, basically providing that if you are paying a janitorial or maintenance service directly for your business, and someone comes in at night and they vacuum and they dust and they do your dishes and they make sure everything's wiped down after COVID-19, and they are not subject to a direct contract for services through a service contract agreement with a business or organization, that janitor, that maintenance person is now your employee. They are not independent contractors. So if you have an individual or if you have a group of people and you don't run through a corporation or an enterprise with a service contract for the janitorial and maintenance services that they provide, you need to be very careful because those individuals may come after you for wage and hour violations. So be careful. I do have a little tip of the trade. This is not a guarantee. This is not a slam dunk. This is not an assurance. But I will tell you that if we're looking to avoid an audit, if you are working one-on-one, meaning your business to an independent contractor who's basically a sole proprietor, you should insist that that individual goes out and forms an entity, whether it's a limited liability company, LLC, as we all know it, an S corporation, a C corporation, or a general partnership. They should go out and expend the monies necessary in order to establish that business. Then they need to obtain their own separate employer identification number, EIN. That means that when you issue a 1099 at the end of any given tax year, you're not issuing that 1099 to John Smith with his social security number attached. Rather, you're sending it to Smith Consulting with a federally issued employer identification number. I want to make sure you understand, this does not obviate the need to satisfy the ABC test we talked about, but it does reduce the risk of a spot audit by the governing agencies, including the EDD, the Franchise Tax Board, and the California Labor Commissioner's Office. So that's just a tip of the trade for you to consider as you're considering whether or not your folks can still be ranked or classified as independent contractors. And then finally on this slide, I've thrown in a bit of breaking news. As I had mentioned at the beginning of this presentation, on Tuesday night last, I should say, Governor Newsom issued a statement that he has specifically delineated as part of the California state budget for 2020-2021, a total of $20 million to increase the enforcement of Assembly Bill 5's provisions. This money will go to the EDD, Employment Development Department, the Labor Commissioner, and other governing agencies so that they can increase the number of filings or claims that are being brought against employers in the state of California. The state is taking this very seriously, in other words. It is now something that we can no longer stick our heads in the sand and ignore the repercussions, because the risk and the costs of exposure are tremendous. And I'll get there in just a moment. All right, so as part of Assembly Bill 5, there were a number of exceptions that were carved out. Many of them were carved out at the time that the bill was passed. I don't want to get too political on this, but basically what it came down to was a pay for play. Which lobbies, which groups came forward with money to advocate and argue that they should be exempt from the provisions of Assembly Bill 5. And as such, the legislature laid out a number of specific exemptions as to who, what, when, and where they would be exempt from Assembly Bill 5. I want to make sure there's something perfectly clear. Just because an industry or a group of individuals is exempted from Assembly Bill 5, it does not mean that there's an automatic rubber stamp that they are appropriately classified as independent contractors. What it means is the old test under SG Borrello will apply. So we have to go back to those 11 points that were laid out in that first slide to determine the degree of control that the business owner is executing over the work being performed by the laborer. It is still possible that people in this group of exemptions will still be deemed independent contractors under the Borrello standard. So please don't misunderstand when I tell you that the theory behind this is they just simply don't have to satisfy the ABC test. They go back and they revert back to the 11-point Borrello test. Among the exceptions, and they're all laid out here on the slides, and I apologize, I should have mentioned at the beginning, don't take copious notes today. My slide deck will be distributed to everyone in a PDF format at the end of today's presentation. So all of this data will be provided to you in written form. Among the exceptions, doctors, dentists, any kind of medical provider, lawyers, architects, private investigators, accountants, securities broker dealers or investment advisors, insurance brokers. So your insurance broker, the person who sells you your insurance, they're not your employee. They can still be independent contractors. Commercial fishermen, real estate agents were actually thrown in at the very last minute. It was an 11th hour addition right before the signing of the bill. It was really fascinating because if real estate agents had not been carved out from this, it would have completely shaken up the real estate industry. And then finally, there is this, what I'm going to call catch-all of professional services. Over the course of the last a year and a half, we've had some clarification as to what is an exemption from the under the professional services standard. And they're laid out here. These may be very specific to your industry, so make sure you're paying attention. But human resources administrators, if you're an outside third-party HR admin person, you will still be deemed to be an independent contractor. This isn't for HR folks who are in-house, who are working day-to-day, 40 hours per week inside your business. It's for outside consultants. Enrolled agents, these are people who are not CPAs, but they're allowed to do taxes. They may be doing your taxes or your bookkeeping. Those folks are still going to be classified as independent contractors in this circumstance. Freelance writers, but here's an interesting one. The legislature picked a number out of thin air. They basically came back and said, hey, you know what? You can be a freelance writer as an independent contractor, but you can't write more than 35 pieces for the same enterprise. So what does that mean? If you have a regular weekly column in a newspaper as a freelance journalist, you are now no longer an independent contractor. You're the employee of that paper. Obviously, that changes the entire construct, the entire history of how business is run in these circumstances. And then finally, one of the carve outs that was added after the fact in January is the fact that licensed barbers, manicurists, electrologists, cosmetologists, and estheticians, in certain circumstances, when they're working their own book of business, they're not being assigned work by a particular salon or business owner, then they can be deemed independent contractors as well. So those are the exceptions that have already been laid out by our legislature. There are a number of potential exceptions that are currently pending right now that I just want to bring you up to speed on so that you know what we're looking at from a big picture standpoint. So first and foremost, the first big win for a business owner in California arose in December of 2019 when the California Trucking Association brought a lawsuit against the state of California. You'll notice the name of the case is versus Becerra on many of these. Xavier Becerra is the Attorney General of the state of California. He is the one that is charged with the enforcement of the provisions of the California Labor Code, including the Assembly Bill 5 revisions. In this case, independent owners and operators of trucks sued the state of California saying, we are truly independent. You did not give us a specific carve out, but we are entitled to be deemed independent contractors. A court up in San Francisco agreed. They enjoined, meaning they limited, they stopped the enforcement of Assembly Bill 5 as it applies to truckers that are owners and operators. Again, very, very small carve out because it's only those folks who own their own trucks, who have their own transport vehicles. If you're working for a big box store like a Walmart or a trucking line, you're still going to be an employee in those circumstances. It's only if they're independent owner operators that they're exempted. That case was scheduled to go to trial in October. With COVID-19, all court dates have been delayed. We probably won't get a final decision on the California Trucking Association case until middle to late 2021. In December also, Uber Technologies brought a lawsuit against Xavier Becerra, claiming that the gig economy should be specifically exempted from the provisions of Assembly Bill 5. Well, unfortunately, their injunction was denied on February 10th of 2020, and shortly thereafter, less than 60 days later, Mr. Becerra, who is our state attorney general, brings a class action lawsuit against Uber Technologies, Lyft, Postmates, and Grubhub, basically alleging that they were out of compliance with the provisions of Assembly Bill 5, and they were attempting to enforce those provisions across the board. That was obviously a big change in the way that things were expected to go. There was an expectation that Uber and Lyft were going to get a limited exemption, but that did not happen. And now they're facing a very massive lawsuit from the state of California. Just skipping down to the bottom briefly, I did want to make sure that I noted after they lost on their injunction in February, Uber and Lyft and Grubhub each put in $30 million towards a November ballot measure here in California. So when we go and vote in our presidential general election on November 3rd, we will also have a ballot measure to vote on to decide specifically whether or not the people of the state of California want to exempt the gig economy workers of the state from the provisions of Assembly Bill 5. Uber, just so that you know, has threatened to pull out of the state of California if they do not win this ballot measure. They basically say it doesn't make sense for our business model to have all of these independent drivers as employees. Therefore, we're just simply going to no longer do business in this state. So there is some risk. I think it's going to be an interesting political battle as we move into November. And it will be fascinating to see how the voters of the state of California go on this, because there are a lot of folks who just absolutely adore Uber, Lyft, Grubhub, Postmates, etc. They love the low cost. They love the accessibility. And if there is a threat of those being lost based upon an employment status, it's possible that there is going to be a carve out designed by the voters of California. All right, so going back up, the American Society of Journalists and Authors, these folks came back and said, hey, remember that 35 pieces that you've limited us to? That's not fair. That's not reasonable. We want a specific exemption. If we're truly freelance, if we're truly writing for multiple locations or multiple businesses, we should be able to do that on our own. That case is pending, but there was no injunction issued. So when there's no injunction issued, the likelihood of this actually going in favor of the journalists and screenwriters and authors is not very high. What was ironic was during the pendency of this lawsuit, my local assembly person, Senator Scott Wilk, introduced Senate Bill 868 that would have specifically carved out journalists, authors, freelance writers, etc., from Assembly Bill 5. That, unfortunately, that bill stalled in committee back in February. As you'll notice, there are several of them on here that have stalled in committee, and much of that is a result of COVID-19. Our legislators are focused more on the COVID issues right now, and rightfully so, rather than making modifications to existing law or adding in new laws on the books. Now, I do believe that some of these will become revived as the legislature picks back up into full swing come August, but unfortunately, it's a really shortened timeline for debate, discussion, modification. So it's entirely possible that many of these bills will be kicked into the 2021 legislative session, so we won't see material changes this year. A couple other bills that were introduced: newspaper distributors and carriers, the people who drop off the Wall Street Journal or the Los Angeles Times on your doorstep. Those have always traditionally been treated as independent contractors. Under Assembly Bill 5, they are not. AB 875, interpreters and translators. That one's also stalled in committee. That one I was actually assisting in putting the language together because of my client that I told you about at the beginning of the presentation. Assembly Bill 1925. This was a really interesting bill. It actually would have exempted all small employers. If you had fewer than 100 employees and under $15 million in revenue, you would have been exempted from Assembly Bill 5. Well, that one's stalled in committee right now. So we'll see what that looks like. I do think that we could see a limitation on application for smaller businesses. I do not think that these numbers make sense, the under 100 and under 15 million. I could see it being under 20 employees and under $3 million in revenue. That may be kind of a bartered or politicized issue that comes out in the coming months and maybe even year. Assembly Bill 1928, unfortunately, was defeated soundly by almost a 4-1 margin, but it basically was designed to repeal all of AB 5. So Assembly Bill 5 went into effect January 1, January 23rd, AB 1928 came back and went, hey, we screwed this up, we should just basically repeal the whole thing. As you can imagine, that did not go over well in our assembly. All right. So let's talk about the dangers of misclassification. If you are wrong and you call somebody an independent contractor when they were not an independent contractor, there will be damages arising from, one, minimum wage violations. You're not tracking the ins and the outs and every hour and every minute that your employees are working because you're treating them as independent contractors. You're giving them autonomy to come and go as they please. The same will be true for overtime violations. If an employee is working more than 40 hours in a week or 8 hours in a day, that will trigger another violation. Meals, rest breaks, pay stub violations, because you're not giving them a pay stub. You're cutting them a check every single week or every single month after they've completed their projects. Violations of California Business and Professions Code. 17200 provides that if you are treating somebody as an independent contractor when they should have been an employee, you are gaining an unfair business advantage over your competitors in the marketplace. And that is a separate claim, a separate cause of action, and actually allows people to go back for 4 years instead of 3 years, as we had previously discussed for the misclassification cases. And then finally, the dreaded PAGA claims. These are claims that can basically bring together a group or a collective or a class of aggrieved employees who, many of which you may have misclassified or treated as independent contractors erroneously. And the penalties and the attorney's fees that go into that can be astronomical. So just be very, very careful. And many people will say, well, you know, what is really the risk? Yeah, I understand what the liability and the exposure could be, but how will they actually know that I'm doing things wrong? Well, first and foremost, I laid it out earlier. If you are sending out any 1099s to a Social Security number, you are already on the radar screen. Additionally, the EDD has come back and said if you're issuing 25 or more 1099s in a given year, you are on their list of red flags. They're going to look at whether or not you really do have 25 or more 1099 vendors that you're working with. The United States Department of Labor has just recently picked up the mantle and started running with this classification issue. It used to be that the Department of Labor would only apply the federal standard. It was a much lower, much easier threshold to abide by. Now the Department of Labor is using the Dynamics and Assembly Bill 5 standards. The Department of Industrial Relations, the Labor Commissioner of the state of California, can bring a claim even if no one has come forward with a complaint claiming that they were misclassified. If they see that you have independent contractors and they determine that they don't think that your business fits the model for independent contractors, they can investigate, they can even bring a claim against you without a complaint being filed. I told you my example about the workers' compensation audit. They're a mess. And workers' comp carriers have picked up on this. Many employers have actually received a notification indicating that beginning July 1, their insurance companies, State Farm, Farmers Insurance, Mercury Insurance, if that's who you have your business insurance through, that they're going to come back and they're going to audit if you have any 1099s beginning July 1. So get this right now so that you don't have the risk moving forward of a workers' comp audit. And then, as always, never underestimate my friends on the plaintiff side of the bar. They are very creative and they work up these wonderful arguments that make new law on who is and is not independent contractors. And understanding that in California, if a person comes forward with a misclassification claim and they hit on any one of those labor code violations I just mentioned, meal and rest periods, overtime, minimum wage, all of those issues, attorney's fees for the plaintiff are awardable. And I will tell you, many times that becomes the tail that wags the dog, basically the motivating factor to keep these cases going. Because I have plaintiffs' attorneys tell me all the time that even if they recover $1 for their client, they're going to get a couple $100,000 in attorney's fees. So it drives up the settlement value on those claims significantly. This is the time to make change. This is the time for you to go back and do an internal audit of all of your policies and procedures, how you're treating your workers, whether they're independent contractors or not, ensuring that if there's any risk whatsoever, that you're sitting down and talking with competent legal counsel that understands how these minute rules and regulations work so that you can make those changes. All right. So I'm running a little longer than I wanted to, so I'm going to fly through a lot of this because most of you who may have heard me speak in December at the Oxnard Chamber presentation have already heard this data, but I want to focus on a couple of points because remember, if we cannot qualify under the independent contractor status, if we don't fit that square peg in the perfect square hole, the reversion back is to employment status, and we must abide by all the rules and regulations that apply with that. And so just briefly, I want to touch on the minimum wage increases. For those of you who are in Ventura County, you are governed by the California state minimum wage. There is no county, there is no local ordinance to govern minimum wage, which is a good thing because in 2020, if you're a larger employer with 26 or more employees, your minimum wage rate this year is $13 an hour. Now, I want to caution you, and the reason that I've got the Los Angeles City and Los Angeles County up here is because many people who work in Ventura County may travel into LA County as part of their regular work day or work week. If an employee is performing work in the city of Los Angeles or in the unincorporated portions of Los Angeles for 2 hours or more per week, you must apply the city or county minimum wage to that work that is being done. It doesn't matter if their home base is in Oxnard or Ventura or Camarillo. It depends on where the work is being performed at that time. And on July 1st, just a week from now, there is going to be an increase in the minimum wage across the board for larger employers. We are now at $15 an hour for all work that is being done in the city or the unincorporated county of Los Angeles. If you do not know what is and is not unincorporated county of Los Angeles, there is a map on the County of Los Angeles Superintendent website. You can take a look at where your people are working so you can make that determination. But the reason we want to make sure we're noting the minimum wage increases is because this actually has a trickle up effect. What do I mean by that? Trickle up means that the people who were at $12 an hour last year that moved up to $13 an hour, they're fine. But the people who are earning $15 or $16 or $17 an hour are now going to want $16, $17, and $18 an hour. Additionally, we'll talk about the exempt salary threshold that goes up every year as a result of that also. But the reason we're talking about employment, the reason we're talking about all these rules is because we want to make sure that you are in compliance with the obligations of the California Labor Code. I spoke about this in December, so I'm just going to touch on this briefly. If an employee works more than 8 hours in a day, more than 40 hours in a week, if they work 7 consecutive days in the same work week, they are entitled to overtime. Just because you have someone on a salary does not mean they are exempt from the overtime rules. You could salary somebody at minimum wage, and it doesn't mean that they're exempt. So there's no legal effect or value to putting someone on a salary. These are the 6 primary categories of white-collar exemptions in the state of California as we know them today. If people are not performing duties that are commensurate with these type of roles, then they do not qualify as exempt. They go back to a regular hourly non-exempt employee, and they must be paid their overtime, and they must receive their meals and rest periods. But for those people who are exempt, your executives, these are folks that are in your C-suite, your high-level managers. These are not line-level managers. Please don't misunderstand that. They have to be spending 50% or more of their workday actually doing managerial oversight work, not production work. You've got your professionals, your doctors, your lawyers, your CPAs, your outside salespeople that have specific, your salespeople who have specific training in their professions. These are people who are usually licensed or who have a higher degree, usually a master's degree or above. Your outside sales representatives, these are your true traveling brush salesmen. These are folks that are going door to door, selling cold calling, computer software development, and then other highly compensated jobs. These are usually not blue collar jobs, they're usually white collar jobs. So these are the categories, these are the general categories that apply to the exemptions. But on top of the work that's being done, on top of the 6 categories we just went through, we also must assure that the employee is earning the minimum salary threshold in order to qualify. Under California's existing law, the minimum salary threshold is $54,080. Understanding that this threshold is governed by the state minimum wage, not regional, not local, not municipal. It is only based upon the state minimum wage. So this year it's $13 an hour, which equates to, and it has to be 2 times the minimum wage. So it has to be $1,040 weekly or $54,080 per year. If someone is earning $54,079, it doesn't matter what their duties are. They could be the CEO of your company, but if they fall below that threshold, they will not qualify for the exemption. And I want to just take a quick rabbit hole here for just a moment. As part of COVID-19, many businesses took steps to protect themselves. They may have furloughed employees. They may have reduced hours. Some people actually just reduced wages across the board. Everybody got a 20 to 25% pay cut. Well, understand, if you had an exempt employee who was close to this threshold and then they accepted a pay cut, they fell below the minimum salary threshold for the month where they worked. They would have defaulted back to a non-exempt status, meaning they were entitled to receive overtime, receive their meals and their rest periods. So if you did that, please, please, please reach out, give me a call or give your attorney a call to make sure that you're not running afoul of this minimum salary threshold. Please note that come January 1, the minimum salary threshold jumps by over $4,000 per year. So if you're not making these changes in advance, being ready for January 1st, you are behind the 8 ball and there is risk associated with that. And understanding that the federal law, so for folks who work outside of the state of California, people who are not subject to our wonderful laws and regulations, the minimum salary threshold outside of California is $684 a week, which is $35,568 per year, significantly lower than us. All right. So that covers all of the basic boiler points that I wanted to go through. I have left 10 minutes here to answer some questions and answers. If we need to go over, that's just fine. I certainly hope you found the information to be helpful and informative. I will make an offer to anybody who is on the call today. We've got about 30 folks on the webinar. If you have a follow-up question that doesn't get answered today, you have my permission to send me an email and just let me know that you attended the Oxnard Chamber presentation, and I will be happy to send that out to you, and I'll respond to you as a courtesy. Nancy, I'll turn it back over to you. So if there are any questions, you can pose them and I will answer.
Well, thank you so much, Brian. Wow, lot of information there, and certainly a lot to make sure that we're complying with. I don't see that we have any questions that have been entered through the question app. Again, for the attendees, that's the little conversation bubble with the question mark in it. If you have a question, please type it in there. I could ask you one question, Brian. I'm aware that that there's a change in the paid family leave as of July 1. I believe it's an additional 2 weeks. Are there other changes July 1st for folks in Ventura County that we should be aware of?
The paid family leave is the only major issue that you'll need to be aware of on July 1. There are a number of things that will be coming up in January of next year. Many of them are wage and hour oriented, but for the July 1, you guys don't have the change in minimum wage that is rolling out for Los Angeles County, San Francisco, Oakland, Contra Costa, and San Diego counties. They all have a July 1 rollout. Ventura County has not implemented its own minimum wage, thankfully. If there are any people from the county of Ventura, thank you. Thank you for making my life easier. So I'm very appreciative of that. There are no other regulations except for the fact that I had mentioned in passing that the workers' compensation element of the Assembly Bill 5 is being enforced by most insurance carriers, most major insurance carriers. Let me strike that. Most major insurance carriers beginning July 1. So they had given a we'll call it a grace period from January 1 through July 1 for their for their insureds, so that they could clean up the independent contractor status before they started auditing and going back 3 years to determine whether or not they should be changing the analysis on who is and is not covered by workers' comp.
Great, great. Well, we've had a couple of questions come in.
Great.
Here's a good one. For exempt salary calculations, do you take bonuses into account?
Excellent question. The exempt salary must be a base salary. It cannot be based upon bonuses, commissions, or any other performance-related metrics. It must be their guaranteed salary on a weekly, monthly, or annualized basis. So if half of their income is generated off of commissions or bonuses, then they would not qualify, except with one very small carve out. On the outside sales exemption, if a person is truly outside sales and they are out, as I mentioned earlier, the traveling brush salesman going door to door and making cold calls, they are allowed to have their minimum salary made up of 50% commission and 50% base. But outside of that very small window of exemption, all others, the executive, the administrative, the professional, the computer related, the other highly compensated, they all must have a guaranteed base income without bonuses or commissions of 54,080.
Great, great. Thank you. That was a good question. The next one I have is a kind of a question and a comment. It just says, just want to know when Brian sleeps. His knowledge and delivery of information is amazingly helpful. A big thank you to Brian and to the Oxnard Chamber of Commerce. So I guess that's it.
I appreciate that. I appreciate it more than you know. I will tell you that the last 108 days have been the busiest of my entire career. My wife asks me when I sleep, and it's not very frequently right now, because staying on top of this stuff has been quite a challenge, obviously with COVID-19. The other issues that we're working on for a number of clients right now are modifying policies regarding equal employment opportunities, race relations. How are we handling this type of protests and leaves of absence when employees ask to go away so that they can attend a protest in Washington, D.C. or downtown Los Angeles? It has been a really, really busy 100 days. So thank you for that comment, though.
And thank you for your presentation so much. We really appreciate it. It looks like that's about it for today. Again, thank you very much. We welcome you back anytime you'd like to approach another topic, because there are plenty of them.
Have show, will travel. I'll hopefully see you sometime later this year or in January for a new employment law update.
Great. Thank you so much, Brian.
Thank you.
Okay. So that concludes our webinar for today. And just wanted to let you know that, of course, our next webinar that's coming up is July 9th. We'll have an update from Sacramento with Assembly Member Jackie Irwin. We're looking forward to that. And we're presenting that in partnership, actually, with the Camarillo Chamber of Commerce. So again, thank you all for attending. Thank you again, Brian. Please have a great rest of your day, and definitely stay safe and stay healthy. Thank
Excellent.
you.
Thank you, guys.
Bye-bye.